You're listening to a special edition of We Get Work, recorded live from Workplace Horizons 2025 in New York City, Jackson Lewis's annual labor and employment law conference. Over 500 representatives from 260 companies gathered together to share valuable insights and best practices on workplace law issues impacting their business today. Here's your personal invitation to get the insights from the conference delivered directly to you. We'll see you in 2026. Welcome to Live from Workplace Horizons 2025 We Get Work podcast series. Thank you, Eric Giddig and Andy Oxman, for joining me in the podcast studio this afternoon. Principals both from the Los Angeles office at Jackson Lewis. So welcome. I'm going to ask an easy question first. I know it's the end of a long day of programming here at the conference, but just introduce yourself and tell our listeners a little bit about your practice and really what kinds of questions you're getting from employers right now.
So I do a little bit of everything sitting in our Los Angeles office, and that means I'm advising and providing counsel to our clients. I also litigate, and that is in connection with single plaintiff or claimant matters, and then also class action, wage and hour matters, along with PAGA, which we're going to talk a little bit more about.
Okay, terrific. Eric?
And I would say I do a little bit of everything also, but mostly I do class and PAGA actions. That's where I'm handling most cases.
Okay, so Andy, session was about PAGA amendments and how recent changes have changed the plight of employers. So tell us what that's all about and what you discussed during your session today.
Sure. So the California Private Attorneys General Act, PAGA, was amended significantly in June of 2024. And so what we discussed were what those amendments mean for employers and our clients and how they can use the amendments and the new provisions that have gone into effect to their advantage, to leverage a defense, and also to be knowledgeable going forward about how they should structure their business, train their employees, and work with their employees.
So big changes, Eric, since 2024. How did that shape the scope of your presentation? And then what really resonated with the attendees?
So I think, in terms of how it shaped the presentation is what those amendments mean for employers now in terms of fighting PAGA cases and limiting the potential exposure in PAGA cases. So we talked a lot about the penalty caps that are in place in the new amendments, about how options for curing under the new amendments, options for having early conferences under the new amendments, standing requirements and manageability requirements under the new amendments. But I think the general focus was, how can we, what are the options in the new amendments to help me in my cases? I get a PAGA case. How can the new amendments help me where the old PAGA law was not so helpful? And I think that's really what we focused on a lot. That and arbitration, the constant battle of PAGA versus arbitration and how those two intertwine.
So I'm sure the attendees had a lot of questions and concerns. Would you share some of those and what your insights were for them?
Sure. We spent a good amount of time talking about arbitration agreements and how that interplays with PAGA, which Eric mentioned. And it's always a big decision for employers to decide whether they want to have an arbitration agreement that employees are required to sign. So we talked about, the advantage of having such an agreement, and there are disadvantages. So certainly employers really need to weigh those. But the advantage of using the standing requirement that the PAGA amendments expressly codified, using that requirement in connection with arbitration to really put pressure on an employee who's bringing a PAGA claim and use that to potentially even shut down a PAGA claim, which previously has been really, really difficult to do.
Okay, that's great. So Eric, what would you add? What were some of the key takeaways you think people, not only in your presentation today, but listening to this podcast should know?
I think most importantly is that for the first time, perhaps ever since PAGA became law in 2004, employers actually have tools in their belt to try to fight PAGA cases, and they don't have to just sit back and say, I'm going to settle right away because it's too expensive to litigate a PAGA claim. There's actually ways now to fight these claims, that did not exist beforehand, and not just to fight them, but to really limit your potential exposure in a case, that may be based on largely frivolous claims. So I think that was the big takeaway. And, aside from that, the other big one is that in terms of fighting a PAGA claim, the best way to fight a PAGA claim is to be in compliance before you get a PAGA claim. So we talked a lot about today, options for doing that, where you can, again, take advantage of new penalty caps by showing that you've taken reasonable steps to be in compliance with the law.
That's great. So, Andrea, good news for employers to a certain extent. How is Jackson Lewis helping employers not only take advantage of the potential opportunity of these changes, but making sure they continue to mitigate risk?
Sure. So Jackson Lewis, and specifically in California, we have a class action and PAGA group, and there are a number of attorneys, in addition to me and Eric, that are handling these cases. And we work and meet together regularly to collaborate, to compare our experiences, because we don't have any guidance from the court yet on these amendments. And so we expect it in the next, couple years, but it's going to take some time. And so we are always working together and thinking strategically about what is going to best serve our clients in different situations. No client, is the same. And so we always take into consideration, risk tolerance, business considerations, and have a number of strategic options for our clients to choose from.
Andrea, Eric, thank you from coming all the way from California to sit behind the podcast mic with us today and truly to be thought leaders here at our Workplace Horizons 2025 conference. Thank you very much.
Thank you.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.